right, I think we should get started. Hello, everyone, and thank you for joining Mayor Brown webinar. This is part of the webinar series of preparing for the coming enforcement surge. In my recent experience, we might need to change that title to preparing for the here enforcement surge, the already here surge. But our program today is going to focus on ESG-related risks worldwide and equipping your organization to face regulators' enhanced arsenals. That is a mouthful, but I am very excited for the panel that we have here today. And for those of you who know me, my name is Rich Rosenfeld. Shockingly to any of you, I may actually listen more than speak today because I am fascinated by the folks who are going to be doing most of the talking. I'd like to introduce the program. I'm a partner in the Washington, D.C. and New York office of Mayor Brown. I co-lead the United States securities litigation and enforcement practice and have for more than a decade. But more importantly, joining me today are my colleagues, Alan Linning, James Whitaker, and Dr. Johannes Weisbrot, and I would like each of them to introduce themselves. So I'm just looking on the screen, and in order that I have, Johannes, would you mind giving a brief introduction of yourself and then maybe pass it along?
Sure, of course. Thanks, Rich. My name is Johannes Weisbrot. I'm partner in the Düsseldorf office of Mayor Brown in the compliance and antitrust groups, and we have been focusing for quite some years now, and in the last months especially, on ESG topics as the new regulations have poured in here in Germany, and we try to equip our clients with all they need for that.
James?
Thanks, Rich. Hi, everyone. Good to be speaking with you today. My name is James Whitaker. I'm a partner in the litigation team in London. I co-lead the firm's ESG practice group, so we are very focused on ESG generally, and in particular at the moment, as Rich has alluded to, and Johannes has alluded to, the wealth of regulatory developments and enforcement-related activity in this area. We look forward to talking to you about these issues today. Thank you.
And Alan, last but not least, Alan, for sure.
Thank you. Good morning, good afternoon, good evening to everybody. My name's Alan Linning. I'm a partner in Mayor Brown's Hong Kong office, and my area of practice is really white-collar crime and contentious regulatory enforcement matters.
Perfect. So before we begin, I've got a few administrative matters that we always do if you've been on another Mayor Brown webinar, you know we always do them at the start of the webinar. It's probably the only time I ever read anything in a webinar. I hate it, but I'm going to do it now. So this one cracks me up because it's a little late. Please note, when accessing Mayor Brown webinars, possibly in the future, via our Zoom platform, we suggest avoiding software such as Citrix, which would probably decrease disruption and quality loss if you don't use it. If you have any questions during the webinar, we invite you to just ask us. Let us know via the Q&A feature on the bottom of your screen. We'll take a look at that throughout the webinar, and if we can fit them in as we're going, we often will. We sometimes have time at the end, and we'll fit them in for a question and answer at the end. And if we don't get to something, we would love for you or us to reach back out to you and answer any questions that you have. So we'll do our best to answer them. Regarding CLE credit, important to everyone, and any other credit around the world, they're, I think, available in a variety of the jurisdictions you may be in. We're going to provide an alphanumeric code during the presentation. In order to receive CLE credit, at least, that's the one I know, I'm sorry, participants must record this code on a virtual sign-in sheet that was emailed to you with the login instructions for today's program. So please return that form back within 10 days of this event by either scanning or taking photos of the form and emailing copies to the Mayor Brown address that's in that invitation. It's cle-events@mayorbrown.com, or by faxing the form to 1-312-701-7711 for anyone who is international. Obviously, there's a 00 at the front of that, so it's +1, but that should be pretty easy to find in the invitation. I won't repeat it. With that said, let's begin, and I'd like to turn it over, if I may, to Johannes. Oh, first, I think, sorry, Johannes. First, I think I'm going to take us through a quick couple of slides. This one I should have had on while I was speaking because it's way more fun than looking at our cover page. I enjoyed it. I always want to make sure I give credit to the artist who wrote it, so it's up there in the right hand corner. But it's a fascinating program that is absolutely worldwide today. ESG is something you are going to have to be considering now and into the future. It is something that for years, at least here in the US, I think everyone paid attention to, but people weren't necessarily thinking through exactly what it would mean or what it was going to mean going forward. And it has just grown for so many factors, and they're all here. But really, I think in each of our jurisdictions, and you're going to hear this today, there is a real drive. It comes from the civil side, it comes from media, it comes from a variety of places, but the regulators have taken up the mantle now. And that's what we're going to talk about today. And in each jurisdiction, you're going to hear about what's going on and what in each jurisdiction you need to be thinking about. So now I'm going to turn it over to Johannes. And thank you for bearing with me, Johannes. With that setup, why don't you talk to us a bit about Germany and the EU?
Yeah, let's start off with the EU, because the EU really has been a very powerful force in driving the agenda on the Green Deal, as they say. And part of this very wide policy area they're pushing is CSR. And there's a whole host of regulations, drafts, directives they have been putting out there in all sorts of areas of ESG. And most notably, maybe the Corporate Sustainability Reporting Directive, which obliges companies to report on their efforts in terms of environmental matters, social matters, and so forth, and the taxonomy regulation, and many, many others. And another subject the EU has put some focus on is supply chain due diligence, and how to make sure that companies in Europe take the responsibility to make the world a better working place. And Germany, actually, so moving on to the next slide, Germany is pretty much on the forefront of this. It's obviously a global trend. We have several legislative measures out in different countries, abolishing sort of slave labor and other things, all of that going back to the United Nations Guiding Principles of Business and Human Rights. And this has been now in the world for quite some time. And now Germany has, as far as we see, one of the most advanced, far-reaching sustainability supply chain due diligence acts, which puts on a lot of obligations on companies active in Germany and having a global supply chain. And it's particularly interesting because it's sort of a paradigm shift. Of course, ESG has always been important with multinational corporates and other companies for reputational reasons and other. But supply chain due diligence now puts a different twist on it, because you will have a liability for not taking enough measures, even if the risk does not result in a damage. So you may be fined if you don't have a sufficient risk management system, even though there may not anything be going wrong. So it's a very good time now to take stock of your compliance management system, and specifically your ESG management system, and align and leverage that to comply with the German laws and then the European laws that will follow. And of course, it's the right thing to do.
Johannes, so just really quickly, that's an interesting, I find that fascinating. Is that something that you've typically seen in regulatory structures in Germany or the EU previously? The US got really excited, at least from the securities regulator standpoint, about not having enough oversight, regulation, supervision, or just policies and procedures in place to manage certain requirements, and even without harm. And so over the last 10 or 15 years, we've seen a tremendous amount of cases for significant tens of millions of dollars in fines here in the US for violations of not having enough of a control environment, even if there was no harm. Is this something that they're used to in the EU, or is this new?
No, I think that's very new. In fact, there has up to now not been an authority in charge of this, because the law is new, and they have. I will come to that later. There will be an authority now, a new department that will take charge of this. But as of now, they have no clue how to enforce it. They just know that they will have to enforce this because public stakeholders are keeping a very close eye on them. But we will have to see how this plays out in the future.
they'll learn. They'll start using it, I'm almost sure, which means that everybody
that's
needs
for
to pay
sure.
attention.
That's for sure.
Yeah.
So moving on to the next slide, I'll just want to give you a brief, snapshot what this law actually, what's within the scope. So in Germany, the law is already in force, and it will come in effective for companies from 1st of January that have more than 3,000 employees and a German seat or business in Germany within an entity. And from next year, so 2024, it will even cover smaller companies from 1,000 employees upwards. If you are not based in Germany, if you just sell into Germany, you may think you're not affected. That may not necessarily be true, because many German companies that have suppliers, and you may be supplying one of those companies, will roll out their risk management measures to companies that supply them, obviously. So indirectly, you may even be affected if you're not fall under these rules. And if you look into the European proposal, which is much wider because it covers smaller companies, and it does cover companies that don't have a seat in the EU, as long as they make a certain amount of money within the EU, they are covered. And that can be quite small. So if you have more than 40 million turnover in the EU, and you make 50% of that in a high risk area, such as agriculture, so you will be covered by the new proposal. So it's quite far reaching. So moving to the next slide, just to give you an idea what is actually covered by this, or what's the aim of these new laws. They obviously aim to protect people and environments within the supply chain. And that goes from, outlawing child labor, forced labor, land grabbing, and all that stuff. And also, on the other hand, so those are prohibitions, and then you have laws that are human rights, basically, of people that should be and must be protected, such as freedom of association, non-discriminatory wages, and so quite far-reaching laws, also in terms of the environment. And the EU proposal goes even further, including things like biodiversity, freedom of thought, which is not religion, but further than that, and also the climate goals of the Paris Agreement. So it's a very far-reaching host of laws and rights. Who is actually in the scope? So or what you have to look at when looking at supply chain due diligence? Of course, your own business, so your own clients, your own offices and so forth, your employees, and then your direct suppliers. In terms of further down the value chain, so your end tier 2, tier 3 suppliers, they're not covered by the German law directly. Only if you have substantiated knowledge of problems, you need to look into them as well. The EU proposal, which may come into force quite soon, that goes further. That actually includes pretty much everyone that is in your direct line of business. So that's a massive difference between the law that's already in place and the law that may come into place. Next slide. Okay, so what does it mean in terms of how much do you have to do? Obviously, if you are a large company having hundreds and maybe thousands of suppliers, how do you deal with risk assessment? It always has to be appropriate. So appropriateness is sort of the key term within the German law. And you are only obliged to do what is appropriate to minimize the risks within the supply chain that you may have or may not have. And the key factors to establish whether a certain measure or a risk management system is appropriate or not is your nature and the scope of your business. Are you a trader with hundreds, thousands of suppliers, or are you just making one product with a few suppliers? Obviously, that's easier to handle. Your influence on the supplier and the severity of the violation that may come into place, and other factors. So the law does not require you to do the impossible, but you really have to stretch yourself to comply with the obligations.
Johannes, it sounds very much like it's going to be, they often are in a regulatory context, hindsight is 2020. That you're going to have the violation, they're going to look backwards as to whether or not appropriateness was there.
Exactly.
Much like reasonableness in the United States. It sounds very much the same.
Yeah, and it's really difficult to tell, and the authority is going to give some guidelines, or is expected. The law requires the authority to give guidelines, and the authority has been hiring consultants to come up with the guidelines. It's yet unclear what will happen, but it's very clear companies are different, and you have to, and I come to that later, in order to comply and make sure you are not caught out in the rain, you need to document why you consider your measures to be appropriate. And if there's a good reasoning behind it, it will be very difficult for the authority to catch you. Okay, next. So also part of the wider compliance management requirements are, for example, implementing a whistleblower system and documenting. So a key point of this, even if you already have a pretty good CSR department and have maybe a very good corporate sustainability report that's really nice and polished, it may not be enough to comply with the requirements of the law, because they're further reaching, and you have to show exactly how you have taken the measures within the risk management system and reflect that in the reports. So it will be a little bit more difficult, and the key point is documentation is everything. And you have to document it in not only towards the authority, but also publicly on the internet. And just a quick highlight, there are massive sanctions. This builds on pretty much the antitrust way of sanctioning. So just to give you a highlight, if you're a larger company, 2% of your average worldwide income is the cap for a fine against this law. So this is a really massive threat. The EU proposal additionally provides for civil liability. That's not the case in Germany, but you can see already the fines can be very massive. And you are also barred from any public procurement proceedings. Next. So as I mentioned, there is a new, or the authority has been set up in a different, sort of separate department. They are starting to work on this law now, and you can expect them to act very swiftly once the law is in place for the companies. So that was what we wanted to say about the supply chain. Just to give you a little bit view on what's happening in other areas of ESG litigation, there are two quite interesting cases now pending in the German courts. One is of a Peruvian farmer in the Andes who is suing LWE, who is a massive energy and commodity company here in Germany, for being supposedly responsible for 1.5 of global pollution since the 1850s or whatever. And these proceedings have proceeded, and they are set to have a meeting in Peru to take evidence. So it's quite unclear where this goes, but it's a very interesting case to follow, because damage has not even occurred yet. He's just claiming that there may be damage to his farm, and it's a direct claim against LWE, who's obviously like on the other side of the world. And then we have another case here in Germany, where a German farmer supported by Greenpeace is suing Volkswagen, and probably a few others will follow, for continuing to produce combustion engines in their cars, saying that that contributes to climate change and his cows cannot feed on their meadows anymore. And that proceeding also has proceeded. So it's very unlikely, in my opinion, that there will be anything material coming out of this, but you can see that these cases have reached the public and have, proceeded. So it's quite something that they're actually happening. What's next? The German Supply Act will come into force 1st of January for larger companies, for smaller companies a year later. And the EU proposal is now being discussed, and we expect that to also come into force, and then with a 2-year lag in the member states. And that will go even further than what we have seen in Germany. So you see, there's a lot down on the road to come. It's not going to be boring.
Fantastic. I know, what we wanted to do was, along with the EU and Germany, thank you, Johannes, was move over to the UK to give a full sense of the continent. So, James, can you take us and talk to the focus and the framework that's happening in the UK right now?
Sure, thanks, Rich, and hello again, everyone. It's great to be speaking with you today about this highly topical and clearly fast-moving subject. So, as Rich says, I want to focus now on the United Kingdom and to talk a bit about the state of play in this jurisdiction with regard to ESG, and more specifically, the enforcement and litigation landscape, the exposures that we're seeing start to emerge, and which I have to say in some cases are very much an established part of that landscape already. So the UK like many other jurisdictions, has witnessed a very rapid growth and focus on ESG issues, as well as legislation, regulation, and indeed enforcement activity, although probably it's fair to say to a lesser extent than, say, the US, which we'll hear a bit more about later in the session. But all of the factors that have been touched upon already in terms of the reasons for the increase in the importance, in the prevalence of ESG, including what might be described as global factors, but also in particular some of the things we were hearing about from Johannes just there, the developments in the EU. These are particularly relevant to the UK, in some cases more so than in other jurisdictions. That said, the UK occupies a slightly strange or perhaps unique position within the wider context of what we're discussing today. And really nowhere is that more clearly the case than in relation to the emerging legislative and regulatory frameworks. So the UK likes to position itself as a leader in relation to ESG, to sustainability and climate action in particular. And this was very evident from the huge fanfare surrounding the Conference of the Parties, COP26, that took place in Glasgow last year. So we have a government, at least for the time being, that is in theory highly committed to the energy transition, to achieving net zero, which is, by the way, statutorily mandated as a target here, which has to be reached by 2050, and more broadly to promoting sustainability in the economy and perhaps society more generally. So it's probably fair to say that both, certainly geographically and perhaps in some respects ideologically or philosophically, the UK is closest to the European Union in the context of ESG. But of course, following Brexit a couple of years ago, it's no longer part of the European Union, and nor therefore is it directly subject to the various legislative and regulatory measures that are coming thick and fast out of the continent, which Johannes has talked about. That said, much of the EU framework may still apply to UK entities, as it may still apply to other foreign entities. For example, if they have operations or sales within the EU jurisdiction. Again, Johannes touched on that. But before we get into how the landscape compares to that of continental Europe, let me just set this up, set the scene a bit. And I'll talk, what I'll be talking about clearly has echoes in the developing European landscape, but I want to talk briefly about the financial sector in particular as a case study, really because it provides a nice microcosm of the broader picture. And you'll see some of these items on the slide here. The UK government's commitment, so its overall plan, such that it is to transition towards what it describes as a green, sustainable financial sector. And this is set out in various documents that have been produced, including most notably a Treasury-produced document called the Greening Finance Roadmap. This was published in October of last year, but it developed an earlier iteration from November of the previous year of 2020. This is the Roadmap to Sustainability Disclosure Standards. Now, probably the most noteworthy element of these so-called roadmaps is the commitment to making the UK the first country in the world to make disclosures aligned with the 2017 TCFD, the Task Force on Climate-Related Financial Disclosures, mandatory by 2025. And this expressly goes beyond the more familiar comply or explain approach that has historically been adopted. Now, amongst other things, the roadmap envisages the introduction of economy-wide sustainability disclosure requirements, SDRs, and this will involve integrated global standards with regards specifically to investment products. And again, this will aim to align with the TCFD recommendations. Similarly, it envisages the introduction of a UK green taxonomy. The aim there is to define the characteristics against which products are to be labelled in terms of sustainability. And I'll come back to how these are starting to play out in a regulatory enforcement context in a moment. But crucially, in the context of what we're discussing today, the roadmap expressly highlights the risks of greenwashing. And greenwashing is defined in these documents, and it's defined as follows, and I'm going to quote here: misleading or unsubstantiated claims about environmental performance made by businesses or investment funds about their products or activities. And again, I want to come back to that in a moment, but the backdrop we have is a move towards a significantly more robust environmental and indeed broader sustainability disclosure framework, disclosure standards in support of this broader aim of greening the UK economy. And I should add, this goes beyond just the financial sector. But it's also worth noting on this slide that the UK has legislated in the area of sustainability, particularly environmental sustainability already. For example, and you see a couple of the provisions at the bottom of the slide here, UK company law already requires mandatory information provision, both for quoted companies and more recently for all large companies subject to certain thresholds, on, for example, direct and indirect greenhouse gas emissions, on energy consumption and efficiency. Similarly, company directors are required to disclose in their strategic report how they have had regard to certain enumerated matters, including the impact of the company's operation on the environment. And again, I'll return to that a bit later in my comments. The Modern Slavery Act you see listed on the slide there, that has a requirement for mandatory annual modern slavery statements. And there has been an accompanying, or there is intended to be an accompanying name and shame policy in respect of non-compliance. But this is, again, really reflective of the trend towards mandatory human rights reporting and broader mandatory ESG-related reporting.
Hey, James.
Yeah, sure, Rich.
Real quickly. So in what you're talking about, it strikes me that the US is seemingly following a lot of the same roadmap here, but it really, the targeting of greenwashing, I'm curious, because that's the US's statement as well. We're going to target greenwashing, and the concept that you can't use this as polish, or if it's not true, or say things that aren't true, seems to be turning to you must say all of these things about what you are doing. And it sounds like you have the same, you're seeing the same thing in the UK from what you're saying. And I was curious, is that right? That's what's interesting, is it's evolving, and I'll talk about this in a second, so I'll stop, but it's evolving from, you can't greenwash, you can't use it to puff yourself, to, okay, tell us all the things you're doing. Are you seeing the same?
Yeah, that's a fair summary, Rich. Absolutely. And I'll talk a bit more about this, but the very definite trend is away from voluntary reporting towards mandatory reporting in all sorts of contexts, specifically with regard to environmental claims. But what you're also seeing, and again, I'll come back to this momentarily, is a much more focused attention being paid to what is being said, to identify very quickly and very clearly where it is just gloss, where it is not substantiated. And you're seeing this from a range of our regulators. And in fact, that will bring me nicely. If we could advance the slide, please, Rich.
Yep.
Thank you. So, okay, well, before I get to that, let me just make a few comments about what's coming next. But Rich, to answer your question, that is absolutely the direction of travel. But you'll see here on the top of this slide a couple of very significant legislative provisions which came into force earlier this year, and which apply on their face to all UK companies and indeed limited liability partnerships, the second of those provisions, subject again to certain thresholds, as well as so-called public interest entities. Now, these provisions require all in-scope entities to provide sustainability, these entities to provide sustainability information statements, and these are to appear in annual strategic reports, and these are to include information specifically on governance arrangements in relation to assessing and managing climate-related risks and opportunities, as well as things like details on process for the internal processes for identifying climate-related risks, and much else besides. So the reason these in particular are so significant is that they are really leading the international charge towards mandatory ESG-related disclosures and standards. And Rich, this is exactly to your point. And these are enforced now. They apply to reporting for financial years starting from 6 April 2022. So these are live now. So this is here. Elsewhere, we have again, in this jurisdiction, but this very much reflects what's going on the continent and indeed in other jurisdictions. We have a concerted move towards mandatory diversity and inclusion reporting, including at board level, and clear indications from the principal regulators of their expectations, particularly for regulated businesses, in terms of sustainability disclosures. And we've seen this in various Dear CEO, Dear Chair letters that have emerged from the principal regulators. So again, this is a fast-moving area, and the movement is in a definite direction towards improvement and alignment of disclosure standards and requirements. Next slide, please. Thank you. So that's all very interesting, but what does it mean from a from a regulatory enforcement standpoint? Well, it's clear that the framework where it's going is moving towards greater mandatory reporting and disclosure requirements, often aligned with what's emerging from the European Union regime, but equally sometimes with some significant divergence. So there's a complex web of requirements emerging, usually with a focus on objective criteria rather than, or perhaps in addition to, more qualitative information. But therein lies a significant difficulty, which is that objective measurement is often either not easy to achieve, or it may be open to interpretation or creative reporting, or at worst abuse. And this risk is magnified, is magnified where there are more requirements and it's not entirely clear that those requirements are fully aligned. Now, this becomes abundantly clear in the context of greenwashing, which we touched upon earlier, but this again is an express focus of the UK government's drive towards improving the sustainability of the UK economy. But crucially for our purposes, it's also a key focus of the regulatory agencies. And we see this, for example, in the Financial Conduct Authority's deliberate prioritizing of challenging firms where greenwashing is identified. I don't know if you'll be able to read the top right insert on this slide, but this is the priority of the FCA to target and root out greenwashing and take appropriate action where it is found. This is a stated priority of the FCA. Now, in one of its recent position papers published towards the end of in December last year, I believe, the FCA stated in terms that it will start carrying out work to assess firms' implementation of the rules once the first disclosures are published. And it went on to state that it will consider taking action if firms fail to make disclosures or if they're misleading or indeed constituted misconduct. So again, this is a very much in focus. Similarly, we have the consumer and competition focused regulators also looking very closely at what is being sold to the public, to consumers, and how. So the ASA, the Advertising Standards Authority, is very focused at present on organizations, and in particular, it has to be said on financial institutions, and how they're communicating to customers about specific products, specific services, and about contributions of the institutions towards global emissions reductions, for example. Similarly, the CMA, the Competition and Markets Authority, this has been active in this area also. It has the power to levy fines against organizations where breaches of consumer protection rules are found to have occurred. Now, what's interesting about the CMA is that it is taking a very close active interest in this area. It published a document last year, towards the end of last year, called the Green Claims Code. And this sets out various minimum requirements for making what it describes as green claims. So in other words, claims regarding the sustainability, the environmental sustainability of products and services. And it also announced that it would begin reviewing companies which make misleading environmental claims from January of this year. So that, again, this is underway and this is already taking effect. One of the first of these was the very high profile, and I would suggest likely to be highly consequential, reviews that it commenced early this year into greenwashing or perceived greenwashing in the fashion industry. This was launched in January of this year, and it was specifically identified what the CMA considered to be risks associated with greenwashing practices in that sector. So I would add also more recently, in March this year, it also announced an investigation and working closely on this occasion with the European Commission into suspected anti-competitive practices amongst vehicle manufacturers with regard to the recycling of end-of-life vehicles. So this is ostensibly an investigation into breaches of competition law, but it's very interesting because the CMA has expressly stated when it was discussing its investigation that this reflects the CMA's commitment to prioritize promoting environmental sustainability through effective competitive markets. So what we're seeing is a more robust approach of the regulators, of a range of regulators to performance in this area, which is developing against this increasingly stringent backdrop. And this is occurring, again, in a range of different contexts, really across all sectors. And it's probably fair to say that the UK is still some way behind other jurisdictions in terms of the extent of regulatory enforcement, but clearly things are moving quickly, and we can certainly expect more activity in this area as we move forward. So Let me talk briefly about litigation exposures before we turn to a different jurisdiction. So the first point to make here, and there's certainly no great insight on my part here, but that's the public scrutiny of corporate performance with regard to ESG factors generally, and perhaps greenwashing in particular, is certainly intensifying. This is a global trend, obviously, but it's certainly a prominent feature in the UK as much as in any other comparable jurisdiction. So what we're starting to see is an increase in related pressure on organisations, whether from their own shareholders and investors, or from a broader range of stakeholders, or from society at large, be that NGOs, pressure groups, not only to comply with the fast developing framework, legislative regulatory framework, but also in many cases to go above and beyond these requirements, to set and then to meet meaningful targets, and in some instances fundamentally to change corporate behaviours. Now, where shortcomings or perceived shortcomings are identified in that regard, there is an evident and growing willingness to use litigation in this jurisdiction to encourage or compel behavioural change. And this has started to emerge in the UK, which it has to be said is taking its lead in many respects from continental jurisdictions, notably the Netherlands, Germany, which Johannes has spoken about, and France. There have been a number of significant judicial decisions, including from the highest court here, the Supreme Court, in recent years, for example, with regard to parent company liability for overseas subsidiary performance, together with other various factors that such as the availability of litigation funding, the availability of collective redress mechanisms, which have contributed to this jurisdiction being seen as a favourable one for strategic litigation. And by strategic litigation in the ESG context, I'm talking really about litigation that's focused less on the conventional recovery of monetary damages and more on effecting behavioural change.
I am going to not work off the slides terribly much, although I'm going to advance them, and we'll see how much I can actually multitask while I'm speaking and advancing slides. For me, that's chewing gum and thinking at the same time, but I'm going to see what I can do. But I want to make sure that I touch, like everyone else has, on the same factors are driving the US. Obviously, each jurisdiction has its own public sentiment, its own media to contend with. But at this point in the US, we're seeing a lot of money flow into ESG. We're seeing ESG funds. And in fact, that's I only want to talk about sort of four things. We could do, and we have, Mayor Brown's done a webinar about 2 months ago on ESG in the US alone, and requirements and coming rules and regulations and disclosure requirements. And I don't want to do that. I'm going to briefly go over what the US has done most recently, 2 main pronouncements on ESG, and then I'm going to get into ESG enforcement in the US because it's here and there's already a few examples, and I want to talk about that. Because in the limited time we have in this program, I want to bring you up to date on what's actually happening right now and give you a sense of what's happening inside the regulator, how they're thinking. You've heard it over and over again that there's a new administration, and at this point there's not, right? We're in the administration that's already here, and we have a chairman that's been here for over a year now, and is pushing an agenda of a variety of regulatory changes, of disclosure requirements, and ESG has been stated by every division at the SEC as a priority of theirs, and certainly that is coming from the chairman and the commissioners on down. So all of the things that you see as the factors that are pushing this forward, the SEC has taken that and is moving forward on its own and making sure that for the SEC, it's a really big deal. So I think most recently and most importantly, the things you're going to want to know are the pronouncements over the last few months that have been made. So on March 21st, the SEC proposed rules to enhance and standardize climate-related disclosures for investors. So really briefly, this is going to require registrants to include climate-related disclosures in registration statements and periodic reports. So all of your filings, if you're a public company, that is a big deal. Or if you file, 20 Fs from outside the United States, these are all going to be required to be included. Really, really briefly, as I said, we had entire seminars on this. Climate risks reasonably likely to have a material impact on the business or the results of operations or the financial conditions or anything related to greenhouse gas emissions. Certainly in certain regulated entities, those are all going to need to be disclosed. The proposed rules that have been put into place are essentially what's your governance related to climate risks, including management and how it's involved, ESG risk and what's likely to have a material impact on your entity, how this affects strategy, your business model, your outlook going forward, and impact events, any severe weather, including financial estimates and assumptions. So some pretty significant, I wouldn't say necessarily new, but broadened disclosure requirements in the US. And what becomes important about that is that on May 25th, the SEC unveiled rules to prevent misleading claims and enhance disclosure further. And why was that done? I think that was exactly what James and I were talking about a minute ago. That was done to target greenwashing. There's two rules that were announced on May 25th. They are intended to prevent misleading and deceptive ESG claims, particularly in US funds. One that's important to highlight, mainly from a funds perspective, is the names rule. So funds with ESG must have that ESG and its claim to have an ESG related investment philosophy must have 80% of its assets in the class that it's claiming. You have to make clear that the SEC is making clear that the names rule applies, and this is greenwashing. If you're going to try to say that you are a green fund, if you're going to try to make claims in a certain area, they want you to be specific about that and be able to back that up when they review it, and review it they will. OC has said that it's one of their priorities. That's the slide. The only thing I'm talking about on this slide, really, that it's an exam priority to include ESG and review this. There's also in that May 25th announcement, which is just literally when we were supposed to do this seminar, was literally a day before it, I believe, that there's increased disclosure requirements for funds. So not just public entities, but funds must disclose specifics about ESG strategies and the impact they seek. So that's in prospectuses, annual reports, advisor brochures. This is subject to public feedback, so it's not there yet. It's not completely a rule, but this is a proposal and a pronouncement. This is where the SEC is headed, and it gives you an idea of how the SEC is thinking. At least in the present administration, which is here for at least a couple more years and change, they are looking to regulate and put in place regulation and requirements and disclosure that, like James said, is becoming mandatory. They are then going to check it with OC, with the exam staff, and going to bring cases that show that they are taking this really seriously. And so that's what I want to get to next. And I think, maybe most important for what's coming next and what you want to know about, from my perspective, they're going to continue to refine the rules and requirements. Interestingly, I had asked Johannes a question about sort of how much have they defined certain terms in certain areas. And James as well. The SEC is saying that it's going to refine these rules and regulations, but they're not yet. So it's up to each individual entity to determine how it's going to comply, because, as James said, we're here. These are becoming requirements. These are things you're going to have to do, and they're going to use enforcement to make sure that everyone is doing it. And I think that that's the most important thing for you to understand. So really quickly, I want to go through a couple of enforcement cases that came out and then turn it over to Alan to talk about Hong Kong. So, what Vale matters, it's in Brazil. It's important that the US Securities and Exchange Commission brought a fraud case, a securities fraud case, nearly exactly 1 year after it created something called the ESG Task Force inside the enforcement division of the SEC. So there's a couple of reasons this happened. One, because Vale trades in the United States, and if you're going to raise capital here, the SEC has shown traditionally often, and with the folks who are on this call, we could talk about Ahold, we could talk about the FIFA case, we could talk about Petrobras, since I just threw in Petrobras because Vale is in Brazil, so they have no fear, the SEC, of working in the Brazilian jurisdiction. Really quickly about this case, it came out on April 28th, again, 1 year after the ESG task force was created. It's the first major case by the ESG task force. That means something. I think they wanted to make a statement 1 year after they were created. It's a 285 paragraph complaint by the SEC, and that's on purpose because the SEC, I think, wants to say these are the facts that we have. This is how egregious it is. And when it's this egregious, we're going to come in. So the SEC claimed that there are false and misleading statements related to the safety and stability of dams, holding toxic waste product that was a byproduct of this Brazilian ore company's work. Interestingly, this all comes from private plaintiffs. The SEC's action is 2 years after the private plaintiffs filed a similar action. And importantly, that case prevailed over a motion to dismiss. So that motion to dismiss failed, and the court explained something in that motion to dismiss that's important, and then I'm going to move on to the next one because we only have so much time. But the court said in the motion to dismiss that certain statements viewed in isolation could be mere puffery. I'm paraphrasing a little bit. They said maybe mere puffery, and now I'm going to read. When the statements are made repeatedly in an effort to reassure the investing public about matters particularly important to the company and investors, those statements may become material to investors. And I think that's greenwashing. If you take what James defined as greenwashing by the UK just a few minutes ago, and you take a look at what the court said in that private plaintiff action against Vale, it's virtually the same. And it is laying out a framework that if statements are repeatedly made that are material to investors, and in this case, the SEC alleges that there were omissions, that Vale knew about the threats of the dam and didn't say anything, and in fact said the opposite, that is going to be taken as not only greenwashing, but fraud in the United States. Now, the other thing that I said, and I mentioned this earlier in one of my questions, that the SEC loves to do this. Johannes, you'll remember that they love to take a position where there's no harm, and I mentioned this to you, but there are actually issues for whether or not your governance is performing. And that's an issue that happened against a large financial institution in the United States. There was an allegation that the funds misled clients about the quality of review, about ESG quality reviews, and whether they were happening always. And that's one thing we say. The SEC doesn't like you to say may anymore, so you have to speak in more absolutes. And when you speak in absolutes, the SEC loves to come in and see whether or not you did it in each and every single case. So you have to watch these disclosures that you're making. If you say you do something, then you're going to have to do it. In this case, the SEC brought a $1.5 million penalty. It's shocking for me to say $1.5 million these days isn't gigantic, but it's big enough. They were making a statement here, and they were making a statement that says, look, if you're saying you're doing something, you better be doing it. And remember what I just said, or we're going to come in and review you in a broker-dealer context, for example, or in other contexts with our exam staff, investment advisors, or we're going to take a look at you and from an enforcement standpoint and determine whether what you said you were doing is actually happening. And if it's not, we're going to bring cases whether or not there's any harm, because these are requirements and you have to follow them. So on that note, I am planning to turn it over to my good friend, Alan Linning. Alan, I tried to get you enough time. We're running against it, but I want to throw it to you for Hong Kong right now.
Well, thank you very much, Rich. The position in Hong Kong is very different, I think, from Germany, the EU, the UK, and the USA. The regulators in Hong Kong are leading the charge, as they are elsewhere, in terms of dealing with ESG issues. In one sense, Hong Kong has come to the party relatively late, and it's really taken shape in Hong Kong in the last 2 years or so. But what the regulators have achieved in 2 years is impressive, and they have shown that they are committed to advancing the ESG agenda, and I'll explain how they're doing it. So the graphic you have in front of you and the one that follows is really just a series of touch points and dates where things have happened. And what we've had since May 2020 is a lot of activity by a group which was set up by the Hong Kong Monetary Authority, which is the banking regulator, and the Securities and Futures Commission, the securities regulator and stock market regulator, who created the Green and Sustainable Finance Cross-Agency Steering Group. Now that's all of the regulators, financial regulators in Hong Kong, plus 2 government departments, plus the stock exchange, all sitting together determining what direction Hong Kong is going to take, particularly as a home and a market for green and sustainable finance. And indeed today in Hong Kong, I believe that one of Hong Kong's listed companies has just issued fairly significant tranches of green and social bonds. So that is one of the aspects that the Hong Kong government is keen to advance. Now, the reality is that because it's really 2 years in germination only, there's a lot of activity. There's been a lot of consultations, white papers, there have been guidance issued, but we haven't seen any enforcement yet because none of the measures that have been talked about or promulgated have yet actually come into effect. But that doesn't matter because the Hong Kong regulators are focused on this, and I think that in the years to come we will see a rapid evolution, starting with climate-related issues. The chief executive of the SFC has determined that they're going to start with climate-related issues, and I'll talk about that in a minute. If you could have the next slide, please, Rich. And this is up until, yes, thank you, that's good. So the big point here really is the structural point is that there is no legislation in Hong Kong which directly deals with ESG issues in the way in which Germany, the EU, the UK or the US has gone ahead. What we have seen thus far is regulatory guidance and some regulatory measures by the SFC, the HKMA, and indeed the stock exchange, who were early adopters of ESG, on what James mentioned earlier, largely a comply or explain basis in terms of the listing rules. So it's climate driven, it's guidance, it's regulatory work, particularly by the SFC, which I'll mention, rather than legislation. Therefore, regulatory risk going ahead for the time being, I think, is lower, but the risks of enforcement by the regulators, particularly the SFC, I think within a couple of years will be there. And I agree with the comments that have been made already about greenwashing, because I am absolutely sure that the SFC will, in looking at fund products and funds that are marketed to investors in Hong Kong, that greenwashing will come up there. Because what the SFC has done is is to amend the Fund Manager Code of Conduct to cover the management and disclosure of climate-related risks. Those changes will come into effect depending on the size of the funds in question and that are managed out of Hong Kong in August or November this year. So very soon, there are going to be requirements in terms of governance, risk management, investment management, and of course, crucially, disclosure in relation to fund-related products. Next slide, please, Rich. So that's what the SFC is doing, and that's the harder end of it. And I think it will be, as a result, the SFC who will be the first regulator who's likely to take some action here, because they have the arsenal of statutory powers under the Securities and Futures Ordinance. They have the will, they have the budget, and they've put out the first guidance, which is truly enforceable. That's not to diminish the contribution of the stock exchange, which was an early adopter of ESG-related issues in 2013, and it has published this guidance. The guidance is in the listing rules, and the listing rules, breaches of the listing rules could, theoretically at least, lead to action by the SFC for disclosure failures. in the future. And lastly, and no means least, the Hong Kong Monetary Authority has issued guidance on what it expects banks to do in terms of its climate-related risk management. Then on to the last slide there, Rich. You're there, thanks. And so regulatory action, much more likely than litigation risk for the foreseeable future. But more is coming. There's great enthusiasm. The government wants to make this a green finance centre. And I think to come with that, there will be more regulation and therefore higher risks of regulatory action, particularly at the moment for fund managers and in the future, perhaps also for corporates. Thank you.
So we have a couple of minutes, and I wanted to make sure that we touched upon, although we put into the packet of materials that you'll be receiving in the slide deck, we put in the ideas of what companies should be doing. And certainly inaction is a tremendous risk. I don't want to take a lot of time to talk about that. Johannes, I am going to throw it to you in 1 minute to talk really quickly about some thoughts about Germany and how to think about this. But to us, we wanted to make sure there's a slide from all of us, right? Making sure you're familiar with the compliance and the evolving legislative and regulatory framework in your jurisdiction is exactly what we wanted to accomplish here today, to show you that this is a global issue, that each jurisdiction, however, is different. Although from the same vein, it's all being driven from the same places. And at the same time, the regulation, although Alan I thought succinctly and well explained that Hong Kong's a little bit different. At the end of the day, I think the enforcement you will see, the regulations you are seeing are all driving towards the same place. So Johannes, talk to us a little bit about some of the specific things you're seeing in Germany, which is really out in front in some ways. And I think as you mentioned, the EU is now stepping further than that. James said the UK is further. I think the US is further, but this will give folks a quick framework of how to be thinking about this.
Right. So what we are helping clients right at this time now is to actually do a small gap analysis, compare what they've been doing in their CSR work so far and what is actually required by the law. And even if they already comply with numerous standards and have supplier vetting, supplier due diligence already in place, maybe by third parties, very well established throughout different industries, you come up in the analysis quite usually that your company is a very good corporate citizen. You want to do everything right, but you're still lacking certain requirements. You may not have a human rights officer, for example, in place, which you need to have under the law. And there are quite a few sort of nitty-gritty parts you need to get right in your compliance management system, which can be quite complex, but is if you once look at it thoroughly, you will realize it's a manageable task to get these risks all aligned and then act accordingly.
And I think interestingly, the rest of the world, that's coming, right? It's those requirements. Right. A specific officer isn't required, but you do have to document and show what you actually are doing. So how do you do that? And I think there's going to be thoughts, and the industry is going to be moving in those directions globally.
Exactly.
Yeah. So exactly. In many ways, that's James. I didn't want to stop you either. If there was anything you wanted to throw in here at the end, but you'll see as I tap through, since we're already past 10 o'clock here on the East Coast of the United States, there's people from all over. You'll see in your packet of materials things we think you should be thinking about, things that you should be considering as you review your own programs or your disclosure, and all sorts of things that you're going to want to, at the end of the day, consider, like litigation risk and other considerations. We've got, Felipe, thank you for the question, although we're past it now. So I'm going to, that is one we're going to have to answer at a later date, but we would be happy to, and we can take that up. And we're sorry that we've run out of time for the question and answer portion of this particular program. But since there's now a question, we will follow up with you after the program to answer that. This is going to wrap up today's program on behalf of Mayor Brown. I want to thank my colleagues. I was actually, at least me personally, I was fascinated to hear slight distinctions in each jurisdiction. Not terribly surprised to hear that many of the jurisdictions are either already there or moving in the same directions, some very forcefully, like here in the US. But I hope everyone found this program useful, at least as a grounding. Some really quick final housekeeping matters for today. There's a link to materials for this program we're going to distribute with an email to you in the next day or two. This has been recorded, so if you'd like to watch it again, please feel free. If you have any further questions, please reach out. Again, for those applying for CLE credit, please note that the certificates of attendance will be distributed within 30 days of the program date. But we thank everyone, James, Alan, Johannes. It was an absolute pleasure listening to you today and learning from you. Thank you so much. And we thank everyone for joining us. Anyone with questions, feel free to bring them. But that ends and wraps up our program for today. Thanks all.